Namaste students. Today's our topic is judicial authority under obligation to refer the parties for arbitration. The Arbitration and Conciliation Act 1996 supplants the Arbitration Act 1940. In the 1996 Act, intervention by courts was limited so that the object behind speedy justice could be well achieved. To further the aforesaid objective, the 1996 Act, Section 8 of the 1996 Act denotes one such provisions which provide for limited judicial intervention, and further the objective by directing the parties to get involved in arbitration on the basis of the arbitration agreement. In domestic arbitration, the use of Section 8 applications in the courts have spiraled over the years. This piece provides an in-depth analysis of Section 8 of the 1996 Act by focusing on the judicial precedents. A condition precedent is stipulated under Section 8. Section 8 of the Arbitration and Conciliation Act 1996 is peremptory in nature. It provides that a judicial authority shall, on the basis of the arbitration agreement between the party, direct the parties to go for arbitration. It also analyzes conditions precedent which need fulfillment before a reference can be made as per the terms on the 1996 Act. P. Anand, Gajapati Raju and others versus PVG Raju. While iterating the periphery of Section 8 of the 1996 Act, the Supreme Court said that the conditions which are required to be satisfied under subsection 1 and 2, Section 8, before the court can exercise its powers are: there is an arbitration agreement. A party to the agreement brings an action in the court against the other party. Subject matter of the action is the same as the subject matter of the arbitration agreement. The other party moves the court for referring the parties to arbitration before it submits its first statement on the substance of the dispute. First question to be analyzed is whether it can be made applicable to a civil dispute. The Supreme Court, while answering to aforesaid in H. Srinivas Pai and others versus H.V. Pai, said that the Act applies to domestic arbitrations, international commercial arbitration and conciliations. The applicability of the Act does not depend upon the dispute being a commercial dispute. Reference to arbitration and arbitrability depend upon the existence of an arbitration agreement and not upon the question whether it is civil dispute or commercial dispute. There can be arbitration agreement in non-commercial civil dispute also. The presence of arbitration agreement is another prerequisite for seeking a reference under Section 8. Section 7 of the 1996 Act provides the diameter of the term arbitration agreement. The importance of arbitration agreement for seeking a reference under Section 8 was emphasized by the Supreme Court in Srimati Kalpana Kothari versus Srimati Sudha Yadav, wherein the court said that as long as the arbitration clause exists, having recourse to civil court to adjudication of disputes and investigations to be resolved through arbitral process or getting any orders of the nature from civil court for appointment of receiver of prohibitory orders without evincing any intention to have recourse to arbitration in terms of the agreement may not arise. Thank you so much.